Yes. Item number 21 has filed an affidavit. Yes, that may be called. No, it can be called. Filing is for the other side. I am appearing for respondent. Who's for the petitioner? When the post the registry, they'll get it listed. Why are you making a mention? That on 16/3/26, notice specifically directed to list the matter on 50. The parties might not pension possibility that listed, it will be listed tomorrow or Friday. They unlisted. No, no, not today. For listing on day after tomorrow, on Thursday. Thursday or next Tuesday, Lord. For hearing or for admission? Admission.
Consent of the order to the document in item number 3 and 4 also. Only 375 applications.
3 and 4. Wait for your turn. Today for item number 5. Can it be taken on 26? Sir, 18 matter. But the file is not here. So even if we fix the matter, we have to call for the file. We are only to take up matters which are urgent. I know. That was item 5. 5. I am sitting on 26. All right. File is not here. All right. There is no order sheet. Where to record it? File to what? But to hear the it is urgent. Petition says only urgent matters. But that's what I basically mentioned. What is first and after 2 weeks? It was filed on 30th of April. Matter relates to that pension phase where the petitioners have been directed or issued notice for withdrawing the higher pension. So can it be taken up tomorrow? Tomorrow. Motion. Let me see. 2,390. It is only in series. So, filing affidavit application today. Correspondence. Director of pension was supposed to not get instructions. That instruction is awaited. Lots of other each time will be granted. After the time is 24. Take down. Submit from study. Please maybe. You will not record. Publish. उसके बाद
Sir, the discussion of this.
Okay.
No, Lordship. We have filed on 30th.
Do you want to file rejoinder?
Much obliged.
Batch of matter. Well, I have received the communication. Well, they have for some time, to connect with the entire account because they are in the election process. That is, the election process relating to AP constable is under question. So the persons are from all the districts of the state. Some records I have received, but the final one of they have communicated yesterday.
some order directing these matters to be tagged together.
My lord,
What are the petition numbers?
my lord,
How much time are you praying for?
but I need to. But this, all the matters are pertaining to.
We will
But
hold it for 2 weeks. Then they are unable to file.
but
Hello.
ask for the, but when we're supposed to instruction received, Lord, for 2 weeks time, filing the PDB in Apollo. The second day.
So there is no such calendar that
Lord,
first
yes,
day, second
Okay,
day.
instruction, Lord. Sorry, Lord.
Time you require.
2 weeks.
Findings completely.
Not sir. Affidavit file not sir. Our affidavit is not on record. Takes time to bring it on record. Copy also they have in 18 they filed the affidavit, they filed reply. In 19 hours
State.
it is copy with me, but it is not on record. Somehow it is. I'll check up.
The affidavit file was
I have to check up whether it is.
it's again a
File here, file 31.
correspondence.
By tomorrow I'll file. If I have to check up. My copy is with me. Not problem.
The pension matter. After 1 week. Then
Instruction received, Lord said. That was not said.
Even these two petitioners, they are working since 2013,
they
2011. And as per the Act, if you notice the page 22 of the petition, the persons who are employed in employment on 4th of September 2013, they are to be declared. Their names were not sent earlier, and Honorable Court directed to forward the name.
I have received an instruction. Mentioned a total number of 1044 posts.
their names are not included.
Yes, Lordship, not in.
Why was it not included?
It was earlier, wrongly, the municipal board, some persons had dropped their name wrongly. and
When?
not send it. That is why, my lord, Supreme Court directed last, my lord, directed to send the name, and now they have sent the name. Otherwise, my lord, all the persons who are
Already
voting,
notification has passed.
No, no. Where is the earlier order?
yes. Nair, my lord, they passed the order on 25 to 26. The municipal board, my lord, has committed district, my lord. They brought their name, although they are voting. There are 6 of our, of the attitude of the board, my lord. That's important.
Type 226, one board was directed to send the name of the person. And after that, they have sending it, and already given notification has issued. Now sanction post cannot be increased.
Without copy the board.
Some rectified list has been sent.
My lord, your lordship
After
may see
the
the
order-
municipal board affidavit at para 6-7. Municipal board affidavit, page 32.
What happened to the other two? There are four names which got
They have
dropped.
not pushed them.
Filed with affidavit.
Chairman.
Board.
Chairman.
What about the director is not filed affidavit?
No, director has not filed. And now this instructional, they say that without
Last
government approval.
occasion, last occasion directed to bring the specific instruction also.
Directed to take government approval, my lord. Because as per the act, my lord, we are settled. And our names were, my lord, only, my lord, can certify from the posting has been started by the chairman against the person who has committed. So they can take the approval of the government. My lord. They say that without approval of government, they cannot increase the.
Approval of government will be subject to proposals being sent.
Yes.
The proposals will have to be considered by the department at the appropriate level
Yes.
before sending for approval. Now, whether the proposals have been sent or not,
But I understand.
That
yesterday,
that affidavit
will it come? Day after tomorrow, the evidence.
Yes, my lord, next Tuesday.
Right.
Then number one and
So it's still, I was about
one and two.
one. It's straightforward.
Reading the complete,
Just put. Yes. Reading
the
the complete.
complete notice, both sides have sent their affidavits also.
This
I'm
is,
saying
this
for
is for the appointment of
public prosecutor
public.
and other additional and assistant public prosecutor. I'm saying for a date for hearing in of the matter. That is the same manner as very high. Of inconvenient 19.
Second.
2nd of June, Lord.
No, second June.
No difficult.
Interim order. The next week.
Highly appreciated.
Interim order. You have to wait for some time, let the other side. Are you there? Yes. Where is the standing counsel for? Hold on, after a while, just wait for the counsel to come. Yes.
Meet legal. My lord, this matters pertaining to reservation in promotional. My lord, already law is stated the Lancaster matter. And here, my lord, what happened, my lord?
You will have to enlighten us with the law.
My lord, I will place that, my lord. Your lordship's order, my lord. Lordship's judgment. My lord, what happened, my lord? The writ petitioner, he joined in the service in 1992, and the merit is at Chapter 1, page 13. 39, my lord, annexure 1. Of the second writ petition, my lord, 35, 65 of 2020. Here, my lord, the writ petitioner challenge the DPC, minutes of the DPC, by which the name of the private respondent has been recommended by the DPC. Kindly come to annexure 1. That this is the merit list dated 13 August 1992. Here, my lord, the writ petitioner is at serial number 6. And the private respondent is at serial number 12. Thereafter, my lord, in 2010, my lord, the private respondent was promoted to the post of Assistant Commissioner of Tax. And there, and the writ petitioner was later on in 2013, he was promoted to the post of Assistant Commissioner of Tax, my lord, height, coal mine at page 45. Number 6. And my next promotion to the Deputy Commissioner of Taxes, the lead petitioner and the private respondent both were promoted together. Height Annex 10 at page 68. Second. Here, my lord, at serial number 11, the lead petitioner, and serial number 3 is the private respondent. Promoting taxes. Next, third promotion is Joint Commissioner of Tax. And in Joint Commissioner of Taxes, the cadastre is high. Cadastre is high, and as per your lordship previous judgment, I will place that in the cadastre of 7 or 5 or 4 or 3, there cannot be any reservation because of the pyramid structure. The above, as per the post-based roster, there cannot be any reservation. Finally, and when the roster was published by the taxation department regarding post of joint commission, that was challenged before your lordship, which is at page 80 and 15. Judgment passed by your lordship, and this judgment has attained final due, it was not challenged. Finally, come to para 1 at page 80. By filing this requisition under Article 226 of the Constitution of India, passing of notification dated 8/3/2013, issued by the Commissioner and Secretary to the Government of Assam Finance Taxation Department, laying down post-based roster in the cadre of Joint Commissioner of Taxes under Finance Taxation Department, and further seeks a direction to consider the case of the lead petitioner and other eligible candidates in the cadre of Deputy Commissioner of Taxes for promotion to the cadre of Joint Commissioner of Taxes without applying the principle of reservation. Now, my lord, kindly come to here, my lord. The roster was challenged before this honorable court, and the my lord, kindly come to paragraph 21 at page 80. The question 21 as to whether in cadre of 5, one post is required to be earmarked for STP having regard to the percentage of reservation provided to such category, that is 10%, which works out to be 2.50. Next, my lord, kindly come to paragraph 23, my lord. In Anindra Chaudhary matter, a single bench of this court was confronted with the question as to whether in a cadastre of 4 there can be any reservation for the reserve categories as per the percentage provided under the Reservation Act. After referring to various decisions of the apex court, this court held that the principle that in a single post cadre, reservation at any point of time on account of rotation or roster would bring about a situation where such posts would be kept exclusively reserved for the members of the reserved category to the total exclusion of the general category would be equally applicable to a case where cadre state is 4. Next paragraph, 24. At this stage, the decision of the apex court in RS guard may be noticed. That was a case where, under the Reservation Act, 21% was reserved for SC. The cadre under consideration had 6 posts, but the existing roster provided 2 roster points for SC category.
What is the percentage for HTP? 10.
10. And this
How many posts are there in joint commissioner?
5.
What is the percentage?
0.5.
0.5.
0.5.
0.5 cannot be rounded to 1.
No. That is this judgment. That is this judgment. And there are 6 other judgments, including the judgment of RS guard, which this court is referring at page 20. The earlier case also, in this judgment, the roster was challenged that was meant for Joint Commissioner of Taxes and Manner. That was also the post of STP. I continue, Manner. Paragraph 24, Manner. The apex court held that if the roster was to be followed, 2 posts would be reserved for SC category candidates, which would exceed the reservation of 21%. Apex court held that court is not concerned with the reasonableness or otherwise the percentage of the reservation. If 21% of post has been reserved for SC, the roster point SC cannot exceed the quota. If the quota exceeds what, then roster point that has been provided will exceed. It was made clear that in the event of any conflict between the percentage of reservation and roster, the former shall be. That means, under any circumstance, this percentage cannot be increased. So here, 10%, that cannot be 0.5. If it is make 0.5 rounded to 1, it will increase. There are 25. Here, in this case, the writ appeal was also filed against the order, and the judgment upheld the judgment of the single judge. There are 25. In Devakumar Datta, this court, after taking into account the statutory percentage of reservation for 3 categories, that is SC, STP, and STH, held that in the cadre of additional chief engineer of the Water Resource Department, having cadre strength of 7 and 10.
In this case, how many are under mention?
5.
5.
Joint commission. Same manner, ditto manner, same fact, same circumstance. That post would be reserved for any of the reserved category candidates in the said cadre, as it would exceed the prescribed percentage of reservation provided to each of the reserved category. Next paragraph 20. In the case that against the aforesaid decision, a writ appeal was preferred in the case of Pavitra Hazarika. The division bench not only upheld the view taken by the learned single judge in Devakumar Datta, but also held that clubbing together the entire percentage of reservation of 3 reserved categories for the purpose of finding out the quota of reservation fixed in a cadre for the purpose of promotion is wholly not permissible. The division bench agreed with the view taken by the single bench that percentage of reservation as increases in respect of reserve category under the relevant statute can only be taken to determine the extent of reservation permissible in respect of each category in cadre. Next, paragraph 27. Another decision by this honorable court on same point, madam. This is from the co-person department, madam. The above view has been followed in the case of Vinod Kumar Agarwala versus State of Assam, reported going so. That was a case relating to promotion from deputy registrar to joint registrar in the co-person department, Government of Assam, cadre of joint commissioner. Joint registrar consists of 7 posts. There are 7 posts were there in the cadre. Applying the above decision, a single bench of this court held that earmarking of roster points for the reserve categories as per the prescribed percentage of reservation would not be permissible in the cadre of joint registrar. Now, finally come to paragraph 8. Therefore, though logically 0.50 should be rounded off as 1, the peril in doing so could be that if it is taken to be so, result in exceeding the percentage of reservation for STP, earmarking of 1 post in a cadre of 5 would amount to 20% reserve. Here, my lord, court held that earmarking of 1 post in a cadre of 5 would amount to 20% reservation, whereas under the statute, the percentage is 10. That being the position, the rounding of principle may not be applied in a case of this nature, as application of such principle would lead to violation of statutory percentage of reservation. Now, my lord, kindly come to the finding, which is at page 87, paragraph 30. Paragraph 30. The net result of the above deliberation is that the notification dated 8/3/2013 is legally unsustainable and is accordingly set aside and quashed. Promotion from Deputy Commissioner of Taxes to Joint Commissioner of Taxes shall be carried out on the basis of recruitment rules in force without any additional weightage of reservation as provided under the reservation. So, my lord, by this judgment, this court held that in the cadre of Joint Commissioner of Taxes, wherein the total cadre strength is 5, there cannot be any reservation in force. And why not, my lord? By citing those judgments of this honorable court along with the judgment of Authorised of the Supreme Court. Now, that being the position, my lord, what happened, my lord? Meanwhile, 2016 OM has come, my lord. That OM was upheld by this honorable court. Thereafter, another OM on 18 January 2023, kindly come to Annexure 1809, page 100. By this OM, by this was given to the effect that there cannot be any consequential continuity. That's why I am placing this OM was upheld by your Lord. Kindly come to page 110, clause 4. Clause 4B. In case of promotion of in Group A services, the quantum of reservation for STH in promotion shall be as per stipulated percentage of reservation available on for this category. This first sentence says that yes, stipulated percentage of the reservation shall be followed. What is the stipulated percentage of reservation in case of STP is 10 and Pedersen is 5. So there cannot be any reservation for STP. Next sentence, Malon. However, SC, STP, STH, government servants in Group A services on their accelerated promotion by virtue of reservation shall not be entitled to consequential seniority.
But if target
Fine. That is the position. Now, my lord, here, my lord,
what is the
state
criteria for promotion? Merit.
now, my lord, here, my lord, I could not furnish the DPC, I which the private student was selected, but I gave the date and the number. And my learned friend, he has furnished the copy of the DPC, which is at annexure 17, page 327. Kindly come to it. If it filed by the taxation department. 327. This is the minutes of the department selection committee meeting held on 4/2/2023 for recommendation of candidates for promotion to the cadre of Joint Commissioner of Taxes from the cadre of Deputy Commissioner of Taxes for the calendar year 2023. Can you come to then can you come first 4 months? Remaining position at present is 1, existing vacancy 4. Now kindly come to cross 5 at page 320. The roster point of the existing vacancy call it RP4 unreserved, RP5 STP, RP6 unreserved, RP7 unreserved. And this clearly shows that clause 5 clearly shows that they are following the roster point without considering the case of Rakesh Agarwal, the judgment which I have just now relied upon. Then kindly come to clause 6. There are 8 numbers of officers under the zone of consideration as per the latest OM of personnel department, namely so. The petitioner is at serial number 6 and the private respondent serial number 7. My lord, kindly consider this list. This list is prepared according to the WEM dated 18/1/23. In that WEM clause 4 is categorically stated that catch-up rule will be followed.
Please.
Para 6, there are 8 numbers of officers under zone of consideration as per the latest WEM personnel department dated 18/1/2023. Here, my lord, the read petitioner was placed above the private resident. So according to the seniority, my lord, seniority has been restored of the read petitioner and he was placed above the private respondent. And for considering 4 numbers of post, my lord, read petitioner was above the private respondent. Now kindly come to B. Following Rule 12(4), requirements of Assam Taxation Rule Service Rule 1995, the Chairman Committee discussed about the principle of merit for finalizing eligibility of candidates for the post of DC. Now kindly come to C. The following officers have submitted last 5 years of research mentioned below. Here, my lord, the ECR of the read petitioner was not placed due to the base reason known by the respondent. And only 5 out of 8, only 5 ECRs were placed.
D, serial number D.
Serial number D, this is the APS category.
APL.
APL. Here, my lord, here has been furnished up to date of the read petitioner and the private respondent. Then kindly come to E, clause E. The committee discussed the Honorable High Court judgment dated 31/3/2016, WPC number 3581 of 2015, Rakesh Agarwal versus Swenson, wherein Honorable Court directed that the promotion from Deputy Commissioner of Taxes to Joint Commissioner of Taxes shall be carried out on the basis of recruitment rules in force without any additional weightage on reservation as provided under the Reservation Act as well. Here, my lord, not sale, my lord. The selection committee has stated what your lordship has decided on 31/3/2016. So no reservation, no additional weightage. Now kindly come to the rest of the paragraph. The members of the committee also perused the matter in view of when so and so dated 3/8/2016 along with latest when personnel department dated 18/1/2023. Now kindly come to paragraph F. Here, my lord, interestingly, further WP and DC department has also viewed file number so and so to continue following reservation provision as in 13-point roster on rotation basis in the cadre of Joint Commissioner of Taxes, subject to maintenance of reservation within prescribed percentage of 22%. Representative from Tribal Affairs Department affirmed the committee that departments to follow 13-point roster on rotation basis in the cadre of Joint Commissioner of State. These findings of the your lordship has. Now, your lordship has held that set aside and was the roster of the Joint Commissioner of State. That judgment.
Which is,
That's how I
everything is.
that is. And 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 the WPT department, like an
That has judgment, no appeal was filed.
no, it has attained finality way back. We are in 2026. The judgment was passed on
But
2026.
what is the provision of law written by the
My lord,
there is a rule that if it is 0.5, then it should be rounded off to 1.
my lord, that is not in case of reservation in promotion. That is reservation in appointment and reservation in promotion. The two different concepts. And RS Garg is very clear on that. If the percentage and that is less, percentage will be. That means if it is STP 10%, STP 10%, 0.5 only. If we round it up, then percentage will go up to 20% instead of 10%. Statute said that it's 10%. Five of Assam Scheduled Caste and Scheduled Tribe Register of Post in Services Act 1970. 5. Reservation for Scheduled Caste and Scheduled Tribes in post to be filled up by promotion. Reservation for members of Scheduled Caste and Scheduled Tribes in post to be filled up by promotion. Any establishment shall be regulated the following manner, namely, there shall be reservation at 7% for members of the scheduled caste, 10% for members of the scheduled tribes, that is the case of the private tribes, and 5% for the members of scheduled tribes. So totally 22%. That 22% of reservation cannot be exceeded upon. That is the law laid down by RS Garg. And that is the settled law in various judgments passed by this honorable court. I'm placing those judgments on. As my lord, I am placing that Devakumar Dr. Assam Scheduled Caste and Scheduled Tribes promotion to the post of additional query whether roster will still be followed for reserve category candidates even after achieving the prescribed percentage of reservation till no. Para 39. Next head note B mana. Reservation clubbing together argument that the percentage of reservation for three categories should club together which is equal percent and the same should be clubbed by the reserve category candidates done by operating the roster contention statement.
You're reading from Devakumar Datta.
Devakumar Datta. Operative part at paragraph 39. Have to be borne in mind that the percentage of reservation as noted above, that is 7% for SC, 10% for SCP, and 5% for ST, is not only applicable for the vacancies to be filled up by direct recruitment, but the said percentage of reservation is also applicable for vacancies to be filled up by promotion. Although a separate 20-point register is given in the schedule to the Act to be maintained, but as has been held by the apex code, RK Savarkar, when a percentage of reservation is fixed in respect of particular cadre and the roster indicates the reservation points, the posts shown on the reserve points are to be filled from the amount reserve category. However, operation of the roster will have to be reference to prescribed percentage of reserve. What is the prescribed percentage? It is for STP 10%, that is 5 will come to 0.5. However, operation to the of the roster will have to be in reference to prescribed percentage of reserve. The prescription being operation of the roster will till the required percentage is estimated in absence of any quota on the basis of the prescribed percentage. There is no question of operating the roster to achieve impermissible percentage of reserve. What is impermissible percentage? Beyond 10% of STP is impermissible percentage. Paragraph 41. Above being the position, I am of the considered opinion that taking into account the respective percentage of reservation earmarked for all the three categories, no reservation of vacancies can be provided to the private respondent, and consequently the selection of the vacancy is liable to be interfered. And next citation, my lord, Punindranath Tode. I-87. Relevant is paragraph 11, 14, paragraph 11. RS Girl versus State of UP reported in 2006 SEC Code 3 that apex code dealing with a similar situation which there were 6 posts.
I think what you're trying to convey is reflected in this Vinod Kumar Agarwal.
Under any circumstances, percentage cannot be exceeded. And these are the judgment relied upon the judgment passed in Rakesh Agarwal's case, which is the case of the Joint Commissioner of Taxes, where the roster, 13-point roster was set aside, was by this one.
The same post.
Same post and same reservation, same person, STP.
Yes.
Now, my lord, the requisitioner was omitted on 3/12/2020, which I have filed one additional affidavit. Then, my lord, by 3/12/2020, after him, another person was promoted. My lord, why I am facing this case, my lord? Now,
What is your claim now? Seniority.
yes, my lord. My lord, kindly,
You want seniority with effect from the date.
they was considered and promoted, which was stated by your lord. My lord, now what the taxation department is trying to give him promotion from that date, from in accordance with that DPC.
Then
Yes,
still today.
my lord.
Then how the promotion?
Only respect to private restaurant.
Private respondent has not been.
No.
Or promoted in the meantime.
I'm promoting. Now they want to give the promotion to the private respondents from the date of that DPC was contacted by, which is at case 327 of their annexation. Not that reason.
Whether the minute relating to
The repeat is done at ITI activity. Of his promotion. The RTI reply, my lord, dated 2/2/26 month. Kindly come to next page, my lord. Address to the requisitioner by SPIO, come Deputy Secretary to the Government of Assam. They provided respond to the requisitioner RTI application. They provided this minute. Minutes of the meeting of the Departmental Selection Committee to be held on 20/11/2025 at 5 p.m. Lokasara Bhavan. Kindly come to 1 due to retirement of 20. Presently, there is kindly condition. See that, my lord. It is not, it is unheard of. Presently, a single post has been kept vacant due to Honorable Gauhati High Court order. Sri Kamalasa Lahiri was recommended for promotion to the cadre of Joint Commissioner of Taxes from Deputy Commissioner of Taxes in DPC meeting held on dated 4/2/23. However, DPC has directed that due to direction of the Honorable Court, promotion would not be made to him without the leave of the court. Letters have been already been written to the standing council to pursue the matter. My lord, kindly see here, my lord, one thing, my lord, how high-handedness of the private he kept out of 5 posts, kept 1 post reserved for himself.
Where is the order of the court?
Yes, ma'am.
Passed in which matter?
In both the cases. The repetition also, I have furnished one copy of the interim order. Which is at page 16. Annexure 16, page 88. Yes, ma'am. I have no grievance if his case is considered now. Because that recommendation is against the law, ma'am. Against the law laid down by this honorable court. At 5 cadres 10 posts, my lord, there cannot be reservation. And kindly see the recommendation of DPC, my lord. They recommended his name under, kindly come to 330. Yes, 330. DPC recommended. Clause I. The committee accordingly considering the relevant aspects recommended the following officers for promotion to the cadre of Joint Commissioner of Taxes from the cadre of Deputy Commissioner of Taxes, subject to leave of the Honorable Gauhati High Court as may be necessary. At serial number 4, the name of the private respondent. And kindly see, in case of Mr. Swencho, who has been recommended for promotion against RP number 5. This is against the law. How they can do that? RP number.
In any case, he is not been
allowed. And my case is this, right? This recommendation recommending the name of the private respondent should go.
Respondent, state respondent.
My lord, one more thing, my lord.
There are two repetitions. First one, that is the PPC my lord 4319, whether they are placing this petition or not, my lord, they have not replied because they have directly my lord referred to the second repetition. There are certain players, my lord, challenges made in this particular repetition. If it is not helping on that, my lord, then my lord, of course, the second one.
4319 is what?
Yes.
My lord, here, my lord. Why I have placed the second repetition? 4319 is the repetition wherein the addition list was changed. Addition list. According to the OM, my lord, he cannot be my senior. When 2016.
Now, what remains in 4319?
4319, my lord, here, my lord, basically, both the repetition are same. Only thing is, my lord, in the second repetition, I have challenged the minute.
Second repetition, promotion of private respondent.
Minutes and promotion of the private rate.
That part, my lord, yes, no appeal has been preferred, that's then. But the, my lord, thing is this, my lord, during the pendency of the disposition, my lord, in 2023, the private respondent case was considered for promotion from the post of DCP to JCP. That is going from that was kept on hold by interim order passed by the government. Now, during the pendency of the disposition,
Promotion was not there.
not promotion, my lord, yes, he was not to be considered with the leave of the. So one post was kept again, but it was considered otherwise by the committee. Now, my lord, that has been put to challenge. That by note of the departmental promotion committee meeting has been put to challenge.
Question is in view of that. Whether the matter of
Basically, on that point, my lord, there is already a judgment of the five. In 2023 also it was five. That particular case was decided that when my lord, reservation is five, there cannot be when the cadre strength is five, there cannot be any reservation in promotion. That order stands. But my lord, what has happened during the pendency of the petition? The present petitioners have already been promoted to the next level post. Respondent 7 has been left out. Now, another issue is, my lord, regarding their seniority. They said that, my lord, the initial promotion to the post of DCP, that is also, my lord, not correct. He should have been below the petitioner. That has been restored in 2023. He has been put above the petitioner in 2023. So even if today the Joint Commissioner of Taxes, that post filled up by respondent number 7, below the petitioner of the. I have got a written instruction in that regard. Consider it. Probably, my lord,
the question would be effective date.
that so they have been promoted in 2025, December 2020. And if the seniority is restored, then, my lord, of course, Lordship will see, my lord, my instruction. Lordship will see the second page. First paragraph, second page. The issue of this petitioner, that is the present petitioner, regarding the matter of restoring their seniority above reserved category candidates was solved necessarily with the issue of the OM dated 18/1/2023. Consequently, their seniority was restored in the department selection committee meeting held on 4/2/2023. The copy of the minus there. Point number 1 of the OM dated states that the policy of reservation in promotion shall continue. The department selection committee decided to follow roster point for the gather of joint commissioner of taxes. Accordingly, roster point number 5 meant for SPP was lying vacant. Departmental selection committee recommended a count to SPP 40%. So, my lord, post Rakesh Agarwal, there is a OM, my lord, that is 18/1/2022. This was considered while considering the promotion of the 5 response from the post of DCP to, my lord, joint committee. My lord, this OM has been upheld by your lord. This particular OM, 18/1/2023 was put to challenge again. And it has been upheld by your lord.
That's approved, my lord. That's approved.
Take up.
Director, my lord.
Then I have filed additional affidavit wherein I have stated that I have no grievance Let the case
No,
of the
there will have to be a
private
direction.
respondent.
It has already been considered.
Yes, Mr.
That has to be set aside, which is not in consonance with that.
There-
Rightly asked. Rakesh Agarwal. Our respective that is the 350 discharge. Subsequent to it, guidelines for implementation of the RK suburb. What RK suburb was saying, was if after the post which appointed correctly. Agarwal was post-based reservation. In Assam, it came only after 2014. When which was put in the challenge in the Rakesh Agarwal's case was a notification of 2013. Authorities did not apply the post-based reservation of RK suburb. Now, let's Assam, after its post-based vacancy system, what it has been following that of office memorandum of 2014. That is, not kindly have a look. Here, the point that the vacancy has to be taken into account after getting a calculation of the percentage. Lordship will have that judgment of the RK Supervisor. It clarified after the post-based reservation, it is only the posts that are earmarked. For cadres having less than 13 posts, Lordship, there is a chart and the figure given in the Act itself that if there are posts and cadres having a strength of less than 13, but then the post earmarked, the persons coming into position will always go as per the system. Then Lordship, the calculation, which is the vacancy basis, Lordship, can we have the RK Supervisor? It distinguishes between the vacancy basis, which is calculated on the basis of percentage. Now, in the roster Lordship, it goes as a running account. For a moment, Lordship will just have one paragraph of RK Supervisor which clarifies the entire position. Okay? But that is says that is what, because the para 3 of the RK Supervisor says after the post-based reservation, it is the roster that has to be followed. If the number and the
Now
post
the-
is earmarked against that post,
In calculating post,
but then it goes to the vacancy list. That is my answer. Year after year, every year there has to be a every year there will be a position which the authorities will have to earmark that system for that and has to be filled by reservation. So Lordship, it goes as a running. Only Lordship
now the only question is why fixing this post?
that is what your Lordship. His point has been answered in the Act itself. It says whether post Lordship may have kindly have this affidavit in opposition.
No, show us the act.
Act, Lord, I have annexed it in the petition. Lord, take up the Act. And my book for a moment, Lordship will have it.
63.
263 schedule 2 Lordship. But model post-based roster for cadres having number of posts 30 or less than 30, if I may remember.
Yes.
The roster showing 9 posts with 1 vacancy, that is the 10th post going to the STH, will always give a percentage of 30%. Yes, then question of this variation will not come for reserve category.
Slight variation of 1 or 2 points is inevitable for maintaining the prescribed percentage of 22%. As such, a model roster is prepared for cadres having 13 or less posts, with 13 posts going to STH is prepared and shown below for guidance of each establishment. Model-based post-based roster for cadres having 13 or posts. Next week, and the percentage, but it goes to the running account. What happens here? Once it has been marked as a post for STH, it will always be. For that reason, but may I invite my Lord to have a artist for but it precisely answers this point that it is neither excessive, neither the percentage is bad. The compilation is prepared, but citation is 1995 AIR 1671. And SCC citation is 1995 2 SCC 745. So it is the first page, the judgment of artist. But my Lord, page number 4. Number. Citing 1995 2 SCC 745. Contention raised by the learned counsel for the petition. The resolution provided under the ensuing government instructions are to be maintained in each department. The roster is implemented in the form of running account from year to year. The purpose of running account is to make sure that the scheduled castes, scheduled tribes, and backward classes get their percentage of reserve vote. The concept of running account in the impune instruction has to be interpreted that it does not result in excessive reservation. 16% of the pool are reserved for the members of the scheduled castes and backward classes. In a lot of 100 pools, those falling at serial number 1, 7, 15% in 91 have been reserved and earmarked in the roster for the scheduled caste. Roster point 26, 76 are reserved for the members of backward class. It is thus obvious that when recruitment to a cadre starts, then 14 posts earmarked in the roster are to be filled from among the members of the scheduled. To illustrate, first point in the cadre must go to scheduled class, and thereafter the state class is entitled to 7, 15, 12, 22, and onwards up to 91st post. When the total number of posts in a cadre are filled by the operation of the roster, then the reserve exchange by the impune instruction is achieved. In other words, in a cadre of 100 posts, when the post earmarked in the roster for scheduled class and the backward classes are filled in the percentage reservation provided for the reserve category received, justification to operate the roster thereafter. The running account is to operate only till the quota provided under the impune instruction is reached and not thereafter. Once the prescribed percentage of posts filled, the numerical test of adequacy is satisfied and thereafter the roster does not survive. The percentage of reservation is the desired representation of the backward classes in the state service and is consistent with the demographic estimate based on the proportion worked out in relation to their population. The numeric quota of posts is not a shifting boundary but represents a figure with due application of mind. Therefore, the only way to assure equality of opportunity to the backward classes and the general category is to permit the roster to operate till the time the respective appointees promotees occupy the post meant for them in the roster. The operation of the roster and the running account must come to an end thereafter. The vacancies arising in the cadre after the initial post are difficult. As and when there is a vacancy, whether permanent or temporary in a particular post, the same has to be filled from among the category to which the post belongs in the roster. For example, the scheduled caste persons holding the post at roster 175 retired, then these slots are to be filled from among the persons belonging to the scheduled caste. Similarly, if the person holding the post at point number 8, 14, 23 retires, then these slots are to be filled from among the general category. But this is important. By following this procedure, there shall neither be shortfall nor excess percentage. Correct. There are after there is a cadastance of 5. After 5, the rooster point 6 will operate. 6 point will come as if the first after the 5 rules have been effective. 6 rules, then 7, 8, 9, 14. After 14, that is what the departments are following. Fact, if I invite my lord at page 180 in writ petition.
We'll continue the hearing on Thursday.
But
Better hearing on Thursday.
Actually,
You ask your colleagues to
my
hear.
lord, I have 2 points.
We are not concluding the
My
hearing. We
lord,
are trying to understand
the-
the issue.
This is the first point. The second point comes from the web 23.
Hearing
As per
first-
the
first-
web, my lord, he can
first
his
let us-
case can
let
be
us
cancelled.
understand. Let us understand
Yes, my
whether
lord.
and then there are judgments, not one but
empty number of
three
judgments,
judgments.
but
No appeal has been filed.
That is
You have
fine.
to give a very strong reason for the court not to follow that,
Correct.
right?
But to my respectful submission before my lord, second conformity comes when we are doing the new memorandum. They come up with the suggestion that even now they are going ahead with the reservation in promotion. So the moment they say so, our High Court judgment in Bhagwan Patel says, Section 5A of Act is
We'll continue on Thursday.
I just first read my eyes closed. Person that is permissible.
Some allegation.
Allegation, but personal.
I think they are represented.
I'm not coming to the.
He has been, there is a departmental proceeding, he has been pronounced. Right. He challenges the entire process of manner in which he is
He's challenging the charge sheet, citizen proceeding, as well as the review. All the remedies available. This coming to page.
the allegation against him.
One is willful disobedience, and other is absence without leave. Absence without leave, in spite of being reminders and in spite of being advised to attend his workplace, he was serving here, in Gauhati, by a transfer order, where a long list of officers were there, including transferred to Numuri. Not join me, but just better. Management health and some back pain or some kind of this has been affected. Was advised by the employer join his place of posting. Was also advised that his job is a desk job; he doesn't have to run around, and also that there is a hospital there in the premises which I not. I've gone to the disciplinary proceeding. I don't find any infirmity or irregularity. that I want to raise is that disciplinary authority, the officer is six. Uh, whether these allegations are substantiated or not, that remains. Whether there will be any conflict of interest or any biasness towards the petitioner by the disciplinary authority. After, everything after. Everything after. Yes, because he was supposed to appear before cannot an officer in an organization cannot challenge the disciplinary law. Challenge the disciplinary law. Then they have no right to refer. Number two, that complaint even in the inquiry officer. According to his request, the inquiry officer was also changed. And a new inquiry officer appointed because he had some certain reservations against the original inquiry. That was changed. Then he was asked to appear before the disciplinary inquiry officer. He appeared there, but he instead of signing the documents and naming his defense assistant or policing document, he sent letters to the management saying that under what authority this document.
They did not participate.
No. Initially, he went there, he did not sign, but he questioned the very constitution of the disciplinary authority. The respondents again replied to him as to why this disciplinary authority legal. According to the petitioner, the disciplinary authority is illegal. He is questioning the disciplinary authority, but instead of appearing, he has sent letters to the management that some instances he said I'll appear before the disciplinary authority only if my letters so and so, the letters dated so and so are replied.
Is there any WS file? I mean,
Not appear. Also, disciplinary proceedings had to be conducted ex parte. During the disciplinary proceedings, the management had reminded him several times. Yeah. And even at his request, as that already submitted, even the inquiry officer was changed because he had certain reservations. So the management changed the inquiry officer. That is. Even after that, he has been writing letters to the management but not appearing. So the disciplinary proceedings proceeded without an expert. And after the presenting officer adduced evidence and filed the document, disciplinary authority imposed a major penalty on the removal of service. But the removal of service should not be a bar for future employment in any center. One of the notices page. One, the main notice starts at 4:36. Right. 4:36. And it's a VBR. By this letter, the 4:36. Here also, he has been given due notice of the by that in penultimate paragraph.
You are hereby directed to show cause in writing 10 days of receipt of the show cause letter as to why your absence should not be treated as voluntary abandonment of service and why orders for the same should not be issued. Note that in case we do not receive any reply within the aforesaid time frame, it shall be construed that we have nothing to say against the aforesaid charges and the undersigned shall be unable to process the matter as been paid. Sign and return the duplicate of the letter as a token of acknowledgement. At 458, my lord, 58. 458 is the CDA which specifies the procedure for imposing major penalty. Subject to the provision of rule. And 6. One is the disciplinary authority or an authority as specified in Schedule 1 may impose any other penalty specified in rule above, provided that no order imposing any major penalty specified in rule shall be made except after an inquiry held in accordance with whenever the disciplinary authorities of the opinion that there are grounds for inquiry into the truth of any misconduct or behavior against the management staff, it may itself inquire into the appoint or appoint any other public servant going to clear off. Now, as I already submitted, my lord,
Yes.
there is no infirmity or irregularity as far as the proceedings. At 503, my lord, page 503. Memorandum of charges, which starts at 504. 503 is 19 March 2020. Memorandum is Avinash Bora, manager, so and so was issued. The so was white, so and so dated December, so and so. And say Avinash Bora replied to the same by his letter dated 20th December 2020. As the reply to the so was not satisfactory, NRL now proposes to hold an inquiry against Avinash Bora, manager, which under Rule 6, Part 3, Discipline and Appeal Rules of Conduct, Discipline and Appeal Rules 1990 for management staff of Numaligo Refinery Limited. The substance of the implications of misconduct in respect of which the inquiry is held is set out in the enclosed statement of articles of charge. Statement of the imputations of misconduct in support of the article of charge is enclosed as Annexure 2. A list of documents by which the article of charges are proposed to be sustained are enclosed as Annexure 3. As provided under Rule 6A, Part 3, Discipline and Appeal of the Conduct, Discipline and Appeal Rules 1995 for management staff of NRL, the Avinash Bora is directed to submit within days of the receipt of this memorandum a written statement of his defense, and also to state whether he desires to be heard in person. See, Avinash Bora is informed that an inquiry will be held only in respect of those articles of charge that are not admitted by him. Should therefore specifically admit or deny each charge of each article of charge. Avinash Bora is further informed that if he does not submit a written statement of defense on or before the date specified in paragraph 2 above, the disciplinary authority may proceed in a manner in accordance with the rules. Attention of Avinash Bora is invited to Rule 16A Part 2 Conduct Rules for the Conduct Appeal Rules 1995 for the management of staff of NRL, and with no management staff shall bring or attempt to bring any political or other influence hereupon any superior authority further his interest in respect of matters pertaining to service in the company. The receipt of this memorandum is to be acknowledged by signing. And this is the memorandum and which is followed in statement of articles of charges from 504. 505 we come to charge number 1. Charge number 2. Petitioner's contention is that he has been applying for leave. But the management, the respondents 2 and 3, they have stated that he has not formally applied for any. 506 are the documents relied upon by the respondents. Support of the charges against Avinash Bora. Now, at page 508 is annexure FF1. It's a reply of the petition. That is a provisional reply. Response, provisional reply, and clarification sought with regard to memorandum dated so and so. And he's addressing the disciplinary authority directly by name. Without designation as an inquiry officer. Now, if my lord comes to 508 and see the reply, substance of his reply, and start from para 3. The charges statements which are noted annexure 1 and 2 of the memorandum dated 19/2021 are not true, are found to be tried irregularly, repetitively, was upon with intention, and are also used to pressurize revenge on me. The charges are made with incomplete information, and charges statements are even not mentioned specifically. And are manipulated, altered with reference to SC notice and is reply dated 28/12/2020. This is believed to be again intentional and irregular attempt to keep pressure, maintain harassment, and to delaying the process, as some individual could not hold the same because of my repeated follow-up, and there is no valid reason for the so-called notice. Its purpose may be totally different. And this time, the delay was also planned by sending the memorandum to incomplete wrong address. The concern for an unnecessary of so-called notice for creating pressure to harm me. I refer to letter so and so mail so and so. My application dated 19/2021. At para 6 again, page 509. For physical presence of inquiry, I hereby confirm my availability at my present location, that is Gauhati, only after 7 days of information inquiry date. Please read this letter also as provisional reply with justification to the memorandum. Any confusion in this letter will be cleared, and any proof required will be executed at the time of inquiry. So these are just some examples as to how we did says that I'll appear only in Gauhati. Setting terms and conditions for the discipline law. Now, this main in the whole issue started the transfer order. Now the petitioner says that I am not well, I have back pain, I am under medical supervision, I have to do physiotherapy, I have to do this and that. So it will not be possible for me to go and join in Moligor. I may be retaining. They are joining now. For local transfers, the period of joining 30 days. And for joining outside the local area, the period of joining is 60 days. So he was posted in Gauhati, then to second Mumbai. Now, that is why he was giving 60 days. He was giving 60 days to join. When before that, he has been writing letters to the management, to the managing director, to the chairman, and was accordingly advised to go and join his place of the hospital there, and he has been given a soft job of sitting on a desk. He is not given any other work by physical activity. But he refused to appear. He has been writing letters. He has been making certain allegations, even against the doctors of Mumbai Hospital, which was advised to attend if he had any difficulty regarding health. Now, after 60 days expired and he did not join, he was sent a mail saying that your presence will be mapped. From now on, your presence will be mapped in polygon finally. You have to be there. Still, they did not join. Finding no other alternative, this respondents when they issue the show cause notice. And the disciplinary authority then appointed an inquiry officer. He made allegations against the inquiry officer. So the inquiry officer changed according to. After that, he started questioning the authority of the disciplinary authority, saying that under what right this disciplinary authority has been appointed, and refused to appear. He refused to sign documents. He appeared once, then refused to sign documents and present his evidence, whatever, or appoint an defendant. He appointed defendant. After he stopped appearing before the disciplinary authority, the proceedings proceeded ex parte. Finally, he was the inquiry officer found 569. At 568, he has been again given an opportunity. Here, sir, we write with reference to your notice of inquiry dated so personal so dated so. Now, the inquiry officer has submitted the inquiry report and disciplinary authority shall take a suitable decision after consultation report. A copy of the report is enclosed. If you wish to make any representation or submission on the report, you may do so in writing to the undersigned in 7 days from the date of receipt of this letter. Kindly note that in case you do not receive any reply within the appropriate time frame, it shall be constituted that you have nothing to say and the undersigned shall proceed the matter has been filled. Please sign a duplicate of the letter in token of acknowledgement. Thank you. So he has been given an opportunity also to reply to the inquiry report. That part of the procedural requirement has been met. (569) is again a note. Inquiry report. The inquiry report starts at page 570. Clause 1 at 570. Below is clause 1, willful insubordination or disobedience, whether or not in combination with others, of any lawful or reasonable order of superior. Clause 1, breach of laws applicable to the establishment or rules made thereunder. This is with regard to charge 1. Then charge 2, clause 1A, absence without leave or overstaying the sanctioned leave without sufficient reasons or proper or sufficient reasons. Clause 1 is violation of conduct rules made by the company. Absence from duty. If a management staff overstay beyond the reasonable period of period of leave originally granted or subsequently extended or is otherwise absent beyond 21 days, continuously with the prior permission or intimation to the competent authority empowered to grant him leave, he shall be treated to have voluntarily abandoned the company's services and the competent authority will pass orders accordingly. The necessity of disciplinary proceedings under the company. But here, my lord, disciplinary rules were held, and the delinquent officer was given a chance to defend himself, my lord, but he did not avail of the opportunity. At page 1 is page 576. 576 at para 5. Findings and conclusions. Why not having 576? During the course of the proceedings of the inquiry, various documents and information provided with the memorandum article of charges, settlement of imputation of misconduct, documents submitted by the presenting officer of examined. The charge officer refused to cooperate and did not send any documents nor submitted any list of different features of the defense system. As such, the findings of the subject inquiry is based entirely on the documents provided with the memorandum articles of charges, statement of imputation of misconduct, and documents furnished by the presenting officer and the witnesses presented by the presenting officer. Finding of the inquiry are noted below. Charge number 1. We're going to state from which documents the inquiry officer relied upon, presented by the presenting officer. That on the email said advise to join his services immediately. That is after the period expiry of the period of 60 days. At 577, it has also stated in the inquiry report. The charged officer has stated medical reasons for allowing him to continue the same job and in the same location, and has submitted medical certificates for the same. After reviewing these medical documents, CGM HR has clearly stated by letter so and so dated 10/9/20 that the reasons given by the charged officer for withholding his transfer do not qualify as a case to be considered on compensation ground. From above, it is clear that in spite of repeated orders and advice, the charged officer did not obey orders of superior. As such, the charge number 1 against the charged officer and the following misconduct is of sub 7 and 30 of Rule 1 misconduct under Part 3 conduct and appeal of management staff. Clause 1(7) again, full insubordination of the subordinate, whether or not in combination with the others of any lawful and reasonable order of its superior. Clause 130, which of laws applicable to the establishment of under this group. Then we come to charge number 2. On the charge, the Abhinav Bora did not join DPN-NRMP. And here did he apply for DCM NRMP reporting officer? See that the charge officer was transferred from marketing department Gauhati NRMP Polygar White of order so and so. It is 5/6/2020. It is from marketing Gauhati department by email dated so and so, advised by DGM HR by email dated so and so to join an NRMP Polygar and report to CM NRMP on or before 7/9/2020, and advised repeatedly by CM HR by personal number so and so dated so and so, again person so and so dated so and so, another communication joint duty in line with the office order so and dated 5/6. Also, CGM HR in a letter reference so and so dated stated that a letter dated 21/9/2020 from the charge officer when charge officer expressed right to apply for leave was forwarded to HOD. Now, minor here, he has only expressed his desire to apply for leave, but he did not apply for it. Was forwarded to the HOD CM, finally for consideration, and also advised the charge officer to formally assume his responsibilities as per the previous office orders. However, the charge officer did not CM finally nor applied for leave from CM NRMP finance. As such, the charge officer remains absent without at 570. His reply letter dated 4/5/2021 against the memorandum dated so the charge officer stated that CM NRMP is not his reporting officer. However, from all above correspondence and office orders, it is clear that the charge officer was to report for CM NRMP finance. He would have the authority to sanction leave once the charge officer. Now, they were respondent number 12, we were telling the charge officer to go and join your place of posting, and then you apply for leave, your superior officer, But he questioned the authority of the reporting officer, CM and NRMP. That is not my officer. The charge officer was released from marketing Gauhati department by email dated 27/8/2020. Advised by DGM HR by email dated so to join at NRMP Bolivar and report to CM NRMP on or before 7/9/2020. However, he did not comply with his official order. The show cause notice on to charge officer by personnel number so dated 2/12/2020 from 7/9/2020 to 12/2020, almost 3 months. The charge officer did not report for at NRMP panel nor obtain any leave from the reporting officer NRMP. As such, charge number 2, charge officer and the following misconduct of Sabrud 8 and 31 of Rule 1 misconduct on the part of conduct discipline and staff by. Second clause 1 is absence without leave or overstaying the sanction leave without sufficient reason or proper or satisfactory explanation is proved. Violation of conduct rules made by the company by clause 27 part B conduct rules absence from duty. The management staff overstays beyond the period of leave originally granted or subsequently extended or otherwise absent beyond 21 days continuous without prior permission and prior primary permission of or intimation to the competent authority empowered to grant him leave shall be treated to have voluntarily abandoned the company's services and the competent authority to pass orders accordingly without the necessity of discipline. 579, the supporting documents have been in 550 again is addressing to the inquiry disciplinary authority as so and so without any formality. And again, here also in replies have been very kind of casual. And para 3, after clarification of my queries, at least about the disciplinary authority supporting rule of NRL, I will submit my reply to a minimum within 10. So he's laying conditions before the disciplinary authority. That you reply to more those letters, then I'll reply to your super notice and your articles of charges. Otherwise, I'll not reply. So ultimately, he ceased to appear before the disciplinary authority, and the disciplinary authority had to respond. As that said in the beginning of the issue here whether Professor Das is that he has made certain allegations, whether there will be actually any bias or conflict of interest. Otherwise, as far as the proceedings is concerned, there is no information. Various letters to directors because he has been allegations everybody.
So Professor Das is immediate disciplinary authority.
Is it
An inquiry officer was appointed.
mental officer was appointed? Actually, he had problem with some Mr. Chaudhary was appointed as an inquiry officer. He had reservations against that officer. According to his, because I think the officer was changed to support.
Initiation of the inquiry.
My lord, because since he had made already, there's one allegation, if I'm correct, that he had been using his punch-in card and given to different person to use his punch-in card in the office. That is correct.
Where is it?
Sir, for the petitioner, had given allegation that he has not been reporting for duty on time. He has been this kind of allegations were there, and but the allegations there is all officers, all even the doctors of Moligar Hospital saying that there's certain allegations. And the fact remains that all this dispute. I don't think my lord. Started 437. I had already taken my lord to the position of major penalties, the requirements that has been complied with. Part 3, discipline and appeal rules is conduct. At page 450. At sub-para 7, page 452, part 3, discipline and appeal rule.
Seven and 8.
My lord?
7 and 8.
7 and 8. Probable from service.
This
Not,
is misconduct.
my lord.
Misconduct is what? Major penalty is
And also, my lord may examine whether the penalty imposed is commensurate with the office commission. But
therefore,
whatever
we are
that
asked. Therefore, is there any reference to suggest that these misconducts will invite major penalty?
is, my lord, because in the scope of itself, my lord, it has been stated. No, my lord.
Category of
Draw your attention to clause 7C part 2 of the CDF is applicable to its cases follows. Has granted powers to the management, the employer. Such cases of abandonment of services not to even have a disciplinary. But it's not even required to have a disciplinary. Clause 27, C part 2 of the CDF. Shall be treated to have voluntarily abandoned the company's services, and the competent authority may pass orders accordingly. Without the necessity of disciplinary proceedings. Transfer order. He has not challenged the transfer order in the appropriate forum. Nowhere he has to challenge the transfer order. He has been only writing letters, and he has never gone and joined this place of proof or applied for leave. My submission, my lord, is that he has no infirmity or irregularity. And only point I want to raise is that whether Mr. Subrata could have been the fact that the petitioner had made allegations against him. Whether it would have any effect.
Are you relying on an authority?
Trying to move itself. Still, Milo has no clarity. What he wants to say, what is the player there.
Therefore, we have to request your presence.
What actually? But all the allegations have been raised only in the report, not the.
Very
568. Page 570. Five 589. The inquiry report, then the order. Another contention he has raised is that the disciplinary authority have been the chief general manager. But as per the notification by the NRL, it has designated the inquiry officer authority. 556. March 12, 2021. Based on approval of the competent authority, the following 5 officers are hereby authorized to exercise the rights of fundamental health matters pertaining to disciplinary. 1. Bhimnes Kumar Gupta to Pratham Kumar Saikia to Nalini Kanta Puragohai. 4. Sri Subhadra Das, that is the disciplinary officer. There is no penalty pointing like that. Certain allegations were made against bias. They could have caused any bias. The general transfer order, not only his name, many officers' names. They've been transferred to various states. 45. And 345. Signed by Deposit Chaudhary, Senior Chief General Manager, HR. At page 346 is the list of the officers who have been done. And the petitioner's name appears at serial number 45. has also lodged FIR against the directors, chairman. Corruption charges, mismanagement charges against the top officers of the
challenge to be then that is about that will have to be that is the concept where besides that is there any other prayer?
five. Prayer portion. No clarity as to what you want. Whatever he has raised, he has responded by duty giving threatening for the same, it false manipulated contradictory charges and so and so. That can be only proved by proved before the disciplinary doctrine. That can be proved. Part of the record. Yes. That is the relevant. The disciplinary authority or the competent authority, having regard to its finding on all or any of the charges, is of the opinion that any of the penalties specified in Rule 2 should be imposed on the management staff, it shall, notwithstanding anything contained in Rule 7, make an order imposing such. What is that definition of the penalty? 7. Coming. Seven is the procedure for minor penalty, and Rule 8 is the special procedure in certain cases.
charges were the statement of allegation that I some reply or participate, concluded ex party. Disqualification. And appeals and revisions and whatever have been. Essentially, the allegation against him is that he is subordination.
So that is proof from documents. Subordination and absence from service without prejudice.
The other claim got to various salary.
Back pay.
After reinstatement, claim is different. But even without reinstatement, even at the present position, is there any
Yes, yes.
claims made? Mr. Bora, is there anything more? Your amicus appointed has taken us to the. Quite a lot of his valuable
Yes,
time.
Lord, yes.
We endorse your gratitude.
But with respect to the amicus curiae, it is very unfortunate that amicus curiae respondent did a
So
story.
Mr. Bora, the amicus is appointed by the court,
Yes,
not by you. You do not need your
Yes,
permission.
Lord. Got it?
We had appointed the amicus to take us through the voluminous papers and the relevant laws. May agree or disagree with his manner of submission is irrelevant. You may disagree. You may have your own submission. But
But
we will only accept your submission subject to the same thing available from the records and supported by
yes,
appropriate
respondent
position.
fabricated a story against estimating just to
You
deliberate.
did not participate in the inquiry.
That I will address nothing one by one. Also.
Ah.
I will go by all the allegations
No,
we
no,
will be
Mr. Bora, even if we accept that yes, the allegation against him does not appear to be correct or was stated against some personal bias or whatever it is. You had enough opportunity to raise these objections before the inquiry. Was there any threat that if you appear before the inquiry officer, you will
I
be
address everything.
put in a jail?
I address everything.
Ah.
And the endowment, just to defeat the provision of just to defeat the Article 141 of Constitution of India. But the learned amicus submission is in line with that because they very systematic deliberate. That is why the submission of the learned amicus is in line with that. If the dishonorable court rely on that only there will be so that it was confirmed. Because prior to issue the so-called notice, they said my leave application for consumer. They cannot merely using a word desire just to alter their standing letter field. They cannot use it. They specifically mentioned that my leave application. Then in the
affidavit in opposition, they confirm that issue. That specifically in affidavit in opposition, the inconsistent there is a contradiction, and in particular issue, there are lots of statements. In one page, if page number 1 they have made a statement, another if serial number 10 they have made a different statement. I will address that. Their duty to speak. A mere silence is not a implied consent, but when there is a duty to speak, that a silence is a consent. It is a well-established in law. They cannot alter their stand after 4 months or 6 months. Before issuing the show cause notice, they send my leave for consideration. Accordingly, they mention in the show cause notice for voluntary abandon of compensation for leave. If I did not went there, Moligar as per the transfer order, but they were doing for 190 rupees. If that is the only allegation, why they issue the show cause notice for leave only? If I am not entitled to take leave, that is a very simple ground. I have when Garnet amicus curiae mentioned that I even mentioned the core ground. Then it's 8 pages document in my recently submitted in interlocutor appeal. But it is very unfortunate that the amicus curiae submission is not in line with that 8 pages document also. But they removal post penalty removal of service. That submission that penalty was they could impose that penalty because there is a misrepresentation, there is a suppression of material fact, there is a misleading and inconsistent and contradictory statement, arbitrary, malified, collusive act, colorable and subversive act, deliberate non-consideration of material, and document on record even by the inquiry officer. That
you are challenging the inquiry. You are challenging the inquiry. Your dismissal. We are not the appellate authority. We are only to see whether procedure prescribed on the law is followed, whether from the materials there anything to say that yes, justice has been caused during the process of inquiry. Now, everything is on the fact that you did not participate in the inquiry.
I participate. That is thus to shifting the burden. As per disciplinary procedure, Honorable Supreme Court guidelines, that it is the duty of the disciplinary authority to prove the allegation. Just to shift the burden towards me, they concluded the inquiry fraudulently. I actually, at this stage, I do not want to use this word, but it is very important to use the word. They concluded the inquiry fraudulently as an expert. That I will address one by one, Lordship.
No, we don't have so much of time. You have to tell us in a nutshell for us to move into these aspects.
If there is a deliberate manipulation, Lordship, and in the epidemic, if I am not able to show this Honorable Court, there will be a grave miscarriage of justice. Kindly allow me to show all those documents one by one, because there is a systematic manipulation, Lordship. It is not possible for a council, even a council, to go those documents within a short period of time to understand the deliberate manipulation. I have gone through for last.
Looking into that manipulation. Why should we look into manipulation?
Because
we are not the disciplinary authority. We are not the appellate authority.
Because there is a intentional just to defeat the provision of the Lordship, just to defeat the constitutional provision, just to defeat the Article 141, 14, 16, 19, 21, Article 141, 300A, Lordship.
The fact remains that did you participate before the inquiry?
I participated.
Where is your WS? Where is the written statement?
Again?
Against the charges which are
Yes.
leveled against you.
The first written statement, Lordship, 508. Lordship, another issue that the learned amicus on that I address the disciplinary authority, Mr. Subodha Das, by his name. But it is not correct, Lordship. The very document it shows that I have mentioned his name, and accordingly his designation was mentioned. But I was send him by name because he did not introduce himself as a disciplinary authority. A document was suppressed for a period of 5 months, just to clarify the document, just to clarify the position of the disciplinary authority. They claim that their document was generated on 12/03/2021.
Which document?
Lordship, that is in page number, Lordship, 554. And I have also give a proof in page number 1362. 554, the original document. Volume 3, Lordship. Volume 3. Volume 3, Lordship.
Volume 3 begins with 551.
Yes, sir. 554.
554.
And I annexed the document with the original document in 556. This document on 12/03/2021. They uploaded it 18 August 2020, after a period of 5 months. This document said that based on the approval of competent authority, the following 5 officers are hereby authorized to exercise the right of functional head in a matter pertaining to disciplinary action as per CDA rule of the company. Only, Lordship, he was only authorized to act as a functional head. That too, subject to the company CDA rule of the company. He was not authorized to do anything, Lordship. He was not authorized to do by violating the company CDA rule, Lordship. This is a
What is the functional head?
Functional head means the highest authority in the department.
So in matters of disciplinary action.
No, Lordship. If he acted as a disciplinary authority with this document, then this is a what we call in law, Lordship, ultra vires. Lordship, it is substantive as well as procedural ultra vires, Lordship.
No. How do you read this order at 556? What's the meaning of this order?
This order is does him giving him an authority of functional head.
Functional head, you read it completely.
Functional head matter pertaining to disciplinary action. So disciplinary action is different thing and disciplinary authority is different. Disciplinary authority was described separately in company CDA rule. And Lordship, coming to the point again, Lordship, this document, they claim that this document was generated on 12 March 2021. But Lordship, can they see the page number? Can they refer the page number 554? That document was uploaded on 18/08/2021. Why they suppress this document for a period of 5 months? This is an official document. They need to upload that in the company Eureka portal immediately after generating this document, even in the next day. And this document was suppressed by a person whose name was Mr. Rajiv Bhattacharya, who was repeatedly involved in a series of issues that created inconvenience for me, Lordship. That Rajiv Bhattacharya with the Rajiv Bhattacharya along with respondent 6, Subrata Das, suppressed my confirmation document for a period of 9 months. Lordship. There is a collaboration act, Lordship, just to defeat the provision of law, Lordship. Actually, why they suppress this document? They suppress this document just to provoke and instigate me, so that they can alter or instigate me to approach the court, so that they can alter their position. Because prior to this document, when they upload this,
you come to page 439. 139, see the definition, disciplinary authority. Authority is specified in Schedule 1.
Yes,
Where is Schedule 1?
schedule 1 is Lordship at page number 472.
472.
Subsequent amendment. Ultimately, that is the relevant document. That is the subsequent amendment.
Initially it was?
It was 468.
460.
What is the group of job group?
Yes, job group is C.
C.
All penalty other than dismissal. Head of the department.
Is the head of the department?
At that time, Lordship MD and I was the head of the department. So only this document they claimed on the August 2021 that he was the functional. But as per this document, this is a 1995 document. As per the document, any kind of officer having the authority of head of the department, that is functional head. Head of the department and functional head are the same thing. That was described in the company secretary rule, the very definition page that this honorable court already gone through. Head of the department means the functional head. As per 1995 document, head of the department can act as a disciplinary. But after the
472, there is an amendment in 2011.
yes, Lordship. This is a 1995 document. As per 1995, the functional head can act as a disciplinary. But after the amendment of 2021, that I enclose in 472.
It is 2011.
Yes, Lord. Functional head of the department, incumbent should not be below the rank of GM.
Is the functional head here in your case?
Yes, he was, as per their claim, right, document dated 12th March 2021, he was authorized to act as a functional. But this, as per this amendment, incumbent should not be below the rank of GM. At that time, he was not a GM, though he was signed as a signed the document as a GM, but he was not a GM. He was in the rank of DGM. Kindly refer to the page 1365. 1365. Following tip. As the Google nullified Lordship, kindly allow me to submit all the details one by one. Then only this one address my understand my refer to the serial number 7.
Five.
Yes. It is Subrata Das, employee number 100386 will be assumed served as Deputy General Manager Marketing, reporting to GM Marketing BD. His place of posting will be one. 2017 circular. 2000, as per this circular, 2017 circular, he was promoted to Deputy General Manager in DGM. This is lower than the rank of DM.
Yes.
But there is another official circular that I annex in page number.
When did he become a GM?
He actually restating his restating the GM. This is the nomenclature center. As my name is Avinash Bora. If tomorrow I doing a affidavit, if I change my name, I cannot take a different rank.
But he was a GM on the date when the show was issued.
No, Lordship, he was GM, Lordship. This is the redesignation. He used it because of his rank.
Redesignation is made by who? By the company only.
Yes, Lordship, but his rank was not changed, Lordship.
There's no question of any rank. It says the person shall not be below the rank of a DGM. Sorry, GM.
GM. Below the rank of GM, but he was not in the rank of GM, Lordship. He was not in the rank of GM. He was in the rank of DGM only.
But he was redesignated as a GM.
This is the nomenclature. His rank was never elevated from GM to DGM prior to issuing the memorandum of circular. Can they allow them to show that he was promoted from DGM to GM? His rank was elevated.
Even if it is renomenclature, the fact remains that he was holding the post of a GM.
But rank, but this amendment, company amendment 2011, if functional has below the
Where is that company amendment again? Page number?
Page number 470. This amendment, any kind of functional head without having any rank authority, any rank and position can act as a disciplinary authority. But after this amendment, without having the rank of GM, one cannot act as a disciplinary authority. That I repeatedly mentioned to them. As they, even in the penalty order, the respondent jumps from one issue to another. He did not address one issue completely. There is deliberate misrepresentation of issue. Even in the penalty order, actually they provoke and instigate me, because there is a provision that so memorandum of charges can be drawn up or caused to be drawn up. Because I was confused that I mentioned in my reply, Lordship. When I submit my reply to the memorandum of charges, I specifically asked, place a query that whether this memorandum of charges was approved by competent authority, or
where is the procedure that it needs to be approved?
Page number rule 6, 458. Volume 2. As the Supreme Court guidelines of the cost to be drawn up and drawn up. That is why he created confusion and suppressing issue, suppressing material and document just to provoke and instigate.
Where is that? Where it says that it has to be approved?
Uh, 458. 438. And
Read.
when it is proposed to hold an inquiry, the disciplinary authority shall frame definite and distinct charges on the basis of allegation against the management staff. Only disciplinary authority is authorized. The charges, together with a list of allegations on which they are based, a list of documents by which and the list of witnesses by whom the charges are proposed to be sustained, shall be communicated to the in written to the management staff, who shall be required to submit within such time as may be specified by disciplinary authority, not exceeding 15 days, a written statement where he admit or deny any of all the charges. This as per this is the procedure of.
Where does it say that it has to be approved by the management?
No, sir. There nothing is mentioned there about
Then
management.
nothing is mentioned, then you cannot imagine it.
No, it is specifically mentioned that discipline authority shall be framed definite in this thing.
And
Sir.
that is okay, we have noticed that. You said that it must be approved by the management.
No, I'm not. If I say something like that, I'm extremely sorry.
Right, right, doesn't matter.
But my submission is that
You tell us in the provisional, you submitted some provisional reply.
yes,
Did you raise this issue that the disciplinary authority is not in the rank of a GM, therefore not incompetent, therefore incompetent?
I mentioned the issue. Actually, I could not specifically mention the issue because they did not confirm it, because they issue the so-called notice by mentioning voluntary abandon of company service. For voluntary abandon of company service, they need not to follow this procedure. This procedure is for major penalty. I repeatedly placed query, but they never confirm me. Even the inquiry officer manipulate the issue. They never confirm me.
Is there a set of proceedings available for the inquiry which was conducted? Proceedings are available. Does it show how this is the issue? Who
He appeared,
participated?
my lord. Admittedly, he came on the first day. He came. He refused to.
Under mistaken.
Came on 23rd of July 2021. He came. He again sought for that same explanation that please clarify or please give an explanation in writing that he is Dr. Das is my discipline authority. Then that letter of 23, please. I was not interested. Then that letter of 9-3 or the order of 12-3, page 556, that was shown to him. He then again claimed that it should be given in writing. He refused to sign. He went away. Then on 23/8 he came. Same thing, my lord. He refused to sign. The proceedings were concluded. The management witness produced the document.
Was there any title to proceed?
Yes, my lord. He was given on 23/7 only. He was said, my lord.
Right, nothing from outside. He said, Lordship, I will probe in this honorable court that the employee officer deliberately not considering the material document on record.
You have no right to do that because you did not participate.
I participate, Lordship.
You did not.
No, I participate, Lordship. I participate. They mentioned that I did not even submit a reply, Lordship. But in their document, they repeatedly mentioned that
You first raised the objection that this inquiry officer, the disciplinary authority is not the appropriate disciplinary authority. But you did not raise any objection.
I
In the reply you show us, you have raised the
yes,
objection.
Lordship. I raised.
Which part?
Yes.
Better he concludes, my lord. Then I'll.
So, if he concludes, then he's got 7 or 8 volumes. He'll require about at least 30 days to hear him.
No, kindly
We can't-
allow me at least 1.5 hours.
No, 1.5 hours will give you 2.5 hours. Provided you answer the queries of the court. We are
Okay.
repeatedly saying that we are not examining your case as an appellate authority. We have to see whether the procedure prescribed is correct, incorrect. You have raised the first objection that the disciplinary authority is not the authorized authority. Now you show us from your reply
Yes, sir.
that you have raised this objection.
I zero is my first provisional response. In 510, case number 10, please confirm the designation of a disciplinary authority to avoid repeated inconvenience. Whether the said memorandum of charges are made by recommendation of appellate authority or appropriate authority as per the CBA
You are
recommendation
reading from page 510,
510.
paragraph
Paragraph 10.
10.
Yes. Please confirm the designation of the disciplinary authority to avoid repeated inconvenience. Whether the said memorandum and charges are made by recommendation of appropriate authority as per CDA recommendation and send the same to.
What is CDA recommendation?
CDA recommendation, that is Lordship, Rule 6, subgroup 3, that memorandum of charges for major penalty can be issued by only by disciplinary authority, or as per Rule 7.
But you have not raised this issue that these charges have been framed against you, or purpose has been issued by an authority not competent. Have you raised this objection?
Yes, that is the objection, Lordship.
This is not an objection. This is
At that
not
time,
an objection.
At that time, there is a misapprehension because they did not confirm that they are following the major penalty rule, because there are three rules. One is voluntary abandon of company service. One is for minor penalty. That for minor penalty, SOCOS is required to be issued by a disciplinary authority, and another is launching major penalty. For voluntary abandon of company service, that kind of disciplinary authority is not compulsory required.
Where is the scope of where in the memo of charges does it say that you have been asked for voluntary retirement of service?
Yes, sir. That is SOCOS page number, Lordship, 436. I did not run away from the enquiry, Lordship. Enquiry officer himself mentioned in the daily order sheet that enquiry was concluded. It is a totally misleading statement that respondent tried to repeatedly impose against. At 436, Lordship, SOCOS notice that the only rule that they impose against me, if a management staff overstay beyond a period of
Yes.
is actually not clear. Can you allow me to go to the they actually spoke this rule actually wrongly, because there is an amendment also. This SOCOS is also arbitrary, and it's violate Article 14 of Indian Constitution and 21. What they quoted in the SOCOS notice 27C, if a management staff overstay beyond the period of leave originally granted or subsequently extended or otherwise absent beyond 21 days continuously without prior permission or intimation to the competent authority empowered to grant him leave, he shall be treated to have voluntary abandon of company service, and the competent authority may pass order accordingly without the necessity of disciplinary procedure. That is, they need not to follow any compulsory procedure to issue voluntary abandon of company. They initiate the proceeding for voluntary abandon of company service and then suppress the issue.
Now in response to this, page number 436, did you submit any reply?
Yes, ma'am. 478.
478.
As the amendment noted, they cannot actually pose this clause 27C separately against me. So there is a subsequent official circular in 2011. That 27 is required to be clause A, B, C required to be read as a whole also. They cannot impose this 27C against me thus arbitrarily. Thus to deprive me from the clause 27 where there is a provision for giving prior permission as well as intimation. Intimation and in case of unavoidable circumstances, permission can be taken at a later period of time. Thus, to defeat that clause, they improperly evoke this clause 27. This is the deliberate.
Now, after this reply, what happened?
After this reply, this so-called notice, they mentioned that I was missing from the workplace. I did not intimate. I did not take prior permission for it, but they hold the issue. I repeatedly asking for status. I submitted this reply on 28th December 2020. From January month 2021, January they completely silent. From February month they completely silent. From 2nd March of 2021, I repeatedly followed for the status of my so-called Mr. Subrata Das respondency repeatedly avoid the issue. On 19th of March 2021, I wrote a letter to CGM HR of Numaligarh Refinery to give me the status, and there I specifically mentioned that to show me the to clarify the disciplinary authority so that I can contact the disciplinary, because he never introduced himself as a disciplinary.
So, Mr. Decca, what happened after page 478?
First, the show cause was issued, Manoj. Thereafter, the charge sheet. Show cause was before the
Issued a show cause.
Yes.
And 1220.
Yes.
1220 you issued. And where the allegation is that it should be treated to be voluntary abandonment of the company service.
Yes.
Which he claims to have replied at 478. After that, what happened?
After that, Manoj, the charge sheet was issued.
So
The charge sheet means the memo of charges.
Memo.
See, in the so-called reply, I confirmed that I did not take prior permission.
But he is raised the argument that the charge reflected in 436 appears to be a charge where his leave or absence beyond 21 days be treated to be voluntary abandonment.
That is under Rule 27C of the CTA rule.
Right.
If we had exercised the power under 27C, Manoj, we could have dismissed him without any inquiry.
That's what we are saying, that this show cause appears to have been issued only for that particular
Yes.
charge, to which he replied.
To which reply.
Then the memo charges are elaborate.
Yes.
In respect of some other charges.
Other charge.
But these memo charges is it preceded by another show cause note?
No.
Same show cause note.
Actually, Manoj, show cause is not mandatory in nature. The CTA rule does not provide that prior to issuance of a memorandum of charges, we have to issue a show cause.
This so-called notice was issued just to suppress the main issue. That transfer order was highlighted by respondent 6 and respondent 5 deliberately. Just to Lordship release me from my duty suddenly so that I cannot take prior permission for it. That is why I mentioned in my reply to the so-called notice that yes, I did not take prior permission for it because you released me suddenly and you were supposed to. There are already a well-established law that I will submit some case law also. That and
Where is the procedure for imposition of major penalty?
Rule 6 page 458. The memorandum of charges, there is no allegation against me that I am not taking prior permission for it. There is no allegation that against my leave intimation. There is no allegation that against my submitted medical document. They waive off all the allegations in the memorandum of charges. That they require, now they claim that my medical documents are not sufficient enough. If my medical document are not sufficient enough as per Honorable Supreme Court Authority Precedent 141, the inquiry officer need to address this issue. Even in case any official not participated in the inquiry, and those documents are already on record. That I will address. That I will address with the Honorable Court one by one.
By some decision of the authority, bad or sufficient, insufficient.
Lordship sees second memorandum of charges. That voluntary abandonment is no longer there.
That's what we are asking you.
Now it's a different set of charges. We are not relying on the voluntary abandonment.
No, there, Lordship.
But there has to be a decision that you're not relying on and you are proceeding in some other grounds.
So how does it affect the
But so that they have concluded that some inquiry is required.
some
If
inquiries?
you go by your rule,
Yes.
the rules are clear that institute an inquiry, go into the truth. Any imputation, misconduct, etc., etc.
You've done that.
So you have done that in respect of one particular charge, to which you replied.
No. That 27C is a separate proceeding. That is a show cause issue for voluntary abandonment of service.
Okay.
Now this is an
But that is
inquiry.
ground because he had been on for beyond the stipulated period. Why should it not be considered voluntary abandonment? To which he filed a reply. Whether the reply was sufficient, insufficient, whether further inquiry is necessary.
Because if you're,
Kindly allow me to comment one
Wait,
thing.
we are interacting with him. You take your seat. We'll let you know.
because the subsequent charge sheet is on a different set of charges.
Then there again has to be a show cause prior to that.
Not mandatory.
Right.
Lordship reads Rule 6, Malad. It does not say that a charge sheet has to be preceded by a show cause.
But then why did you issue the charge sheet show cause?
Show cause was
At
issued,
page
Malad.
number 436.
Show cause was issued, but that is not mandatory in nature, and that will not preclude me from issuing the charge sheet.
See, you were instituting an inquiry against a person
Yes.
without letting him know why you want to institute.
I need not let him know, Malad,
Right?
because the memorandum of charges itself is the notice. Prior to instituting a disciplinary proceeding, Malad, the employee did not know. I did not issue a show cause, Malad.
But you see, read see,
Yes.
these rule 6 are very clear that there has to be an opinion of the disciplinary authority to inquire into the allegations.
Yes, the charge sheet itself is the opinion, Malad.
I think that can be accepted.
Because it is not, the rules to nowhere says that it has to be preceded by a show cause.
The disciplinary authority suddenly can decide that these are the allegations that issue a charge. How can that be? How can that be? There has to be some decision of the disciplinary authority recorded in your file movement.
That we have to see whether that
Ah.
record is there or not. But
We have to.
the disciplinary authority, when there is a misconduct, Malad,
Now you see, come to 6.3.
yes,
It says where it is proposed to hold an inquiry. Proposal.
the disciplinary authority.
That's right. So there has to be, you can't
Yes,
say
that,
that
this
this
is
proposal
the
has
charge sheet,
to,
Malad.
proposal will be reflected in the charge sheet only.
Lordship will kindly come to page 503. The Avinash Bora was issued a show cause notice dated 2nd December, and Mr. Bora replied to the same by this letter dated 20th December. As the reply to the show cause notice is not satisfactory, NRL now proposes to hold an inquiry against the Bora under Rule 6 of so-and-so disciplinary rules for management staff. The substance of the imputations of misconduct in respect of which the inquiry is proposed to be held is set out in the enclosed statement.
Charges are different.
Charges are different, my lord. He gets an opportunity to reply, my lord. Yeah.
You accept him. You give him an opportunity to reply. He replies.
Yeah.
You accept the charges.
We do not accept, my lord.
You accept the reply, and then you say that this is not sufficient.
No, we do not accept, my lord. We reject the reply because the reply is
You
not
accept in a
satisfactory.
sense that you have perused the reply,
You have perused the reply, and we should say that the show cause reply is not as satisfactory.
not satisfactory.
Not satisfactory. So
Then
please answer.
Then your
My lord, it is
normal course of action should be to impose. Go for the procedure which you have confronted him by issuing show cause. To
Yes.
which he replied.
He gets a chance, my lord. It is not that we have proceeded against him on the basis of the charges in the memorandum of charges without giving him an opportunity to reply, my lord. He gets a chance to reply to this 19 March.
In response to this, where is the reply?
508.
508.
But he submits two replies. 508 he says is provisional in nature, and then he submits another, my lord, at 526. No, not 526. I'm sorry.
486.
486.
Another reply.
Submits two replies.
Then the proceeding starts.
Then the
You have the records.
I have the
Have you gone through the records? Invite us to not get a copy, but if you want, we can permit you to go through it after he goes. Make notes and then argue, but we can't say that keep the records.
Put some allegations. They completely remove those allegations.
Want to see the records first
That-
regarding your participation.
Currently available in the daily order sheet. The inquiry officer himself did not want to continue the inquiry without getting a signature on the document. I specifically mentioned that if I get a clarification on the issue, because prior to that proceeding, inquiry officer misled me by mentioning that Mr. Subodho Das' respondency is the discipline random, but he did not mention the issue in the first daily order sheet. That I immediately replied.
All right, we'll continue with your hearing. We have understood your case. We record our deep appreciation. When further, Mr. Sharma, you go to the record. Thursday is convenient. We'll take up on Thursday, or
Can it be next Tuesday, my lord?
next Tuesday would be 12.
12.
12. We'll take it up on 12. Take it up on 12 at 2 p.m. Yep. Try to complete the hearing on that day.
Can you allow me to at least,
But you want to
Address-
go to this?
no, can you allow me to, that day allow me to just release of event?
But you also want to go through the record.
Yes, sir. This honorable court allow me to permit to make a copy that.
The copy will not permit. But Mr. Sharma, you go through it, and maybe by Thursday you can hand it over back to Mr. Dekar. I mean, subject to permits. And thereafter, Mr. Dekar will allow.
Go through the record, my lord. Making copies. Let him go through, let him take notes.
Further hearing.
At 2 o'clock.
2 o'clock. Mr. Dekar.
1 and 2. 2 and 3.
NRL.
2 and 3.
Mr. H. Das, Senior Counsel, assisted by Bravo.